Undue influence is an equitable doctrine which applies when one party uses the influence over the other party to enter into a contract. The doctrine of undue influence provides a remedy where the contracts have been entered into as a result of improper pressure. This usually occurs due to a relationship between the parties being exploited to gain an advantage. The main purpose of undue influence is to protect individuals from entering into a contract outside of free will and consent. In simpler terms, that would mean that a party is exerting dominance over the other party over the influence of the position of trust in the making of the contract. And there's also a few common remedies in undue influence, whether it is to be voiding the contract or the rescission of the contract, which directly translates to that the claimant has a choice whether they could affirm the contract in their favor or cancelling the transaction of entering into the contract with the defendant. From here, we will dive into how English and Malaysian law define, identify, and address undue influence, showcasing the similarities and differences between these two jurisdictions. While both law jurisdictions were made to safeguard the integrity of the contractual relationships, ensuring that agreements are entered freely with no influence from the other party.
Hi, my name is Livaneshwara and my student ID is 0362665. Today, the first case that we will be discussing is the case is about Chandran, who owns a multiple textile shops in Kuala Lumpur. Needed capital for his business in January 2023. He convinced his wife Devi to use her house as a collateral for a bank loan, promising her a share of his business profit. They went to the bank together and the bank manager Alan recommended Devi to accept the offer but advised her to consult her own lawyer. Lacking her own legal counsel, Devi had a brief meeting with Chandran's solicitor, who failed to explain the risks. Consequently, Devi signed documents pledging a house as a security to the bank. Chandran and Devi is a married couple. Devi's consent may be questioned because she did not have independent legal advisor when she agreed to use her house as collateral. This lack of independent advice might suggest that she didn't fully understand the implication of the decision, raising concerns about the validity of her consent. There is also a risk of losing the house if Chandran failed to pay the loan, and moreover, the lawyer failed to address the risks that she may face when she comes into the contract. We can see from the scenario that Chandran persuaded Devi from the line. Chandran persuaded Devi to use her house as a security loan. He is negotiating with his bank, in reason for which he promised to give her a share in the profits of the business. Cases where the mere existence of a special relationship between the parties gives rise to presumption of influence, but the innocent party must still go on to show the influence was undue. Under Contracts Act 1950, Section 16, Class 2A states that where he holds a real or apparent authority over the other, or where he stands in fiduciary relation to the other. Now for cases, Public Finance Berhad versus Lee B. Rubber Factory 1994 states that the certain classes of relationship by themselves and nothing more do give rise to presumption of influence. For example, man and his fiancée. However, husband and wife do not fall within the category of special relationships for the purposes of the law relating to undue influence. The affection and the confidence inherent in the marital state does not ipso facto amount to undue influence. In such cases, the issue is whether the party seeking to enforce contract has knowledge or notice, actual or constructive, of the undue influence. Barclays Bank versus O'Brien cited with approval. In the case of Barclays Bank versus O'Brien, the defendant were a married couple who took a second mortgage on their home as a security for overdraft facilities extended by Barclays to the husband's company. The wife has no interest in the business before execution. The branch manager advised the couple to seek a legal advisor prior to signing the documents. The wife eventually signed the documents relying solely on her husband's false representation that the deed was limited to 60,000 pounds sterling and would last 3 weeks only. In the end, the husband's company reached 154,000 pounds overdraft as a result of Barclays sought an order for possession of the mortgage security. That is the couple's home. Then the wife appealed in the court. The House of Lords held in favor of the wife. That's all from me. Thank you.
As explained by Trital under the English law, a contract is when one party had induced the other to enter into the transaction by actual coercion, which equity regarded as improper, but which does not amount to duress at the common law because there was no element of violence to the person involved. As we have seen in the preceding case, this is a problem involving undue influence. Undue influence does not have a precise meaning or a definition, but roughly speaking, it means that one party's influence over another is such that the latter agrees to the contract with the former, which he would not have done absent the influence. Influence in and of itself is perfectly acceptable, but only when it becomes excessive is the contract voidable at the option of the innocent party. As in the case of Chandran and Devi, the issue is whether there was undue influence when the parties entered into the agreement and whether Devi is entitled to cancel it. Presumption of undue influence, as stated by words, phrases, and maxims, the compliant only needs to show, in the first instance, that there was a relationship of trust and confidence between the compliant and the wrongdoer, of such a nature that it is reasonable to assume that the wrongdoer abused the relationship in procuring the compliant to enter into the consented transaction. In this case, Class 2B of the presumed undue influence can be used. This is when there is no special relationship between the parties, but the fact shows that one party has put trust and confidence in the other in the past, which leads to a presumption of influence in the transaction at hand. In this situation, the question is whether undue influence existed, and if so, how do we prove it? To begin with, the burden of proof falls on the defendant to demonstrate that there was no undue influence. This means that the dominant party, Chandran, must demonstrate in relation to the agreement and whether transferring Devi's house would be beneficial for her, as demonstrated in the case of Alucard and Skinner. Aside from that, she must show that the contract is unfavorable for her because she could risk losing her property if Chandran does not pay. Furthermore, as done in the case of Barclays Bank plc and O'Brien, where a creditor is put on notice of the risk of misrepresentation or undue influence by the principal debtor, the obligation of surety will be enforceable if the principal debtor's undue influence, misrepresentation, or some other legal wrong with regard to the surety is proven, and the creditor has failed to take reasonable steps to be. And the other party must advise Devi not to discuss the potential liability and risk in the presence of the other party, which is Chandran. Despite the fact that the advice was provided independently by Chandran's solicitor without his presence, his solicitor failed to take reasonable steps to ensure that the surety entered into the obligation freely and with knowledge of true facts by failing to explain to her the risk involved with her house. And in conclusion, Devi has the right to rescind the contract since, despite the fact that Chandran's solicitor provided her with independent advice, he neglected to explain the risk related to her house.
Hello everyone, my name is Yashwini P. Swarnam. My student ID is 0363733. I will be talking about FOA's situation in nation possession. Let's have a short introduction for undue influence. Undue influence refers to the pressure to enter into a contract by another person's influence without involving direct force or violence. It involves someone with authority manipulating others to enter into a contract, or being induced to do so, or abusing the relationship or the power. In this case, who are now regretting entering into a security contract with the bank under Chandran's persuasion. Here, the first issue arises whether Chandran was in the dominant position to accept the undue influence. Under Section 16(1) of Contract Act 1950, a contract is induced by undue influence if one party, the wrongdoer, controls the will of another and uses it unfairly to gain an advantage. The complainant must prove that the other party dominates their will to prove undue influence. In the case of Raghunath Prasad vs. Charku Prasad, where the plaintiff gave the defendant a mortgage loan with a high interest rate like 2%, claiming it was secured under duress, the Privy Council found that the defendant violated Section 16 of the Indian Contract Act, which is parallel to our Contract Act 1950. The Privy Council ruled that the parties were lender and borrower, and the burden of proof for the unconscionability and undue influence claim could be applied. The law now puts the duty on FOA to prove that his friend Chandran was in the dominant position to dominate the money and uses that position to gain an unfair advantage. Second, how can the complainant FOA prove that Chandran was the one in the position to dominate the will because of the persuasion? Section 16(2)(a) and 2(b) of the Contract Act 1950 allows someone to control another person's will if they have authority over them, or are in a fiduciary relationship with them, or make a contract with someone who is mentally capacity is affected by old age, illness, or distress. However, the Act does not define a fiduciary relationship, which is a trust and confidence based relationship between a fiduciary and a beneficiary. The relationship can be between a doctor or patient, a solicitor, or a client. In Tunku Abdul bin Sultan Abu Bakar vs. Muhammad Latif bin Shah Mohd, the appellant broke their fiduciary duties by outsourcing the contract negotiation. Fiduciary relationship can be classified as Class 2A and 2B, depending on the situation. Class 2A refers to a dominant person over the patient, while 2B involves a relationship where the complainant repose trust and confidence in the wrongdoer. In Sultan Berhad vs. Abdul Rohif bin Karakina, the court ruled that the undue influence over the husband violated under Class 2B principle. So in this case, Fuad and Chandran's relationship can be classified as a fiduciary relationship under Class 2B due to their friendship, because Fuad has reposed trust and confidence in Chandran due to his frequent advice, requests, and putting him in a dominant position as in a fiduciary relationship with Fuad. So next, the third issue is whether the bank in-house lawyer advised to Fuad can be considered the exercise of Fuad's independent decision to sign the contract. The wrongdoer can fight the presumption of undue influence by proving that the person who made the deal did it so freely and of their own free will. In Singaporean case, Foy Chueng Huang vs. Paul Poi, the court ruled that the independent legal advice was not necessary to rebut the presumption of undue influence. The case involved Ng Si Ki, the mother of the defendant, who claimed she was induced to give the share to the defendant by his undue influence. The court found that the mother who passed away was an intelligent woman who acted independently even if the lawyer was acting for the both parties. Applying this to the Fuad case, the lawyer carefully explained the risk involved, making the transaction a free access of Fuad independent decision, as Fuad knew the risk beforehand. Lastly, the issue of whether Fuad can claim under the undue influence is a complex one. The burden of proof is explained through Section 16 3A, where the excess of undue influence has been established. The person accused must demonstrate that the transaction was illegal and the other party act freely without undue pressure. The burden of establishing that the contract was not induced by undue influence falls on the person who was in a position to dominate the will of other person. So the first thing to analyze is not to the unconcernability of the contract but the relationship between the parties. Section 16(3)(b) does not amend Section 111 of Evidence Act 1950, which requires the person in active confidence to demonstrate the transaction was made in a good faith. In Saw Gek Bong vs. Chong Ye Wing, the court agreed that the undue influence applies to the commercial transaction. In conclusion, Fuad must show that his friend Chandran had the power to control the contract, but however, there is no undue influence can be proven because Fuad signed the contract is on his own will. And that's all for Fuad's Malaysian position. Thank you.
Actual undue influence in English law refers to a case in which one person was admitted to the action by another party whose quality was determined as inappropriate. This, however, does not amount to duress at common law as there was no hint of violence involved. There are a few elements of undue influence under English law, and these elements were set up by Lord Hobhouse in the case of Royal Bank of Scotland and Edwidge. These are the elements as followed. So firstly, is that it is an equitable wrong committed towards another party done by the dominating party, which is a clear-cut sign. Secondly, for the dominant party to use his legal rights against the other party, it should be highly inappropriate. Thirdly, there must be some explicit behavior that interferes with the other party's will, something that easily influences them to make that decision. And lastly, a pre-existing special relationship of influence is not necessary between the parties for actual undue influence to exist. So now to address if Chandran was in a dominant position to demonstrate undue influence, we will now look at the case of CIBC Mortgages, PLC and PIT. Facts of this case are a husband who pressured his wife to sign a charge over their matrimonial home, which is a joint ownership, as a loan security in favor of CIBC for its stock market. So given that she did not have any legal advice, the charge was stated to be under refinancing the matrimonial home. However, the husband used it on stock market. So when CIBC attempted to enforce the charge, the wife raised a defense under undue influence by her husband. It was then held that CIBC was not entitled to enforce the charge. The wife managed to establish undue influence by her husband, and CIBC also were not affected by this due to several reasons. One, being that they weren't aware of the undue influence. Secondly, the husband was not acting as CIBC's agent while it happened. And lastly, they did not have constructive notice. Therefore, Chandran now has to be proved of actual undue influence that he was in a dominant position to use the money for an unfair usage. Secondly, is the issue of how can Fuad prove that Chandran had dominated the will. Fuad would have to prove that there was indeed a pre-existing special relationship between them, and this gives rise to the influence presumption and comes under class 2A of presumed undue influence. There also needs to be a trust and confidence pre-existing relationship, and this gives rise to a presumption of influence that whatever transaction made was presumed to be avoided. This comes under class 2B of the presumed undue influence. And the next stage requires them to have some sort of explanation about the transaction on the dominant party. So now the courts will determine if the transaction itself is in nature to be avoided and decided if there is a need for an explanation. If it is, then it arises to a rebuttable presumption. The dominating party then has to explain to have the presumption rebutted. So finally, the courts will consider if it is rebutted or not. This applies to the earlier case that I mentioned, which is the Royal Bank of Scotland and Edwidge. A case involving a husband and wife, where 8 homeowners who had mortgages in their homes had to get it in order for their husband's businesses. So with the wives not having any benefit whatsoever, the businesses failed and the bank wanted to seize their property.
So given that the wives were undue influence, House of Lords explained that the banks are to ensure that each client receives legal advice before transactioning or signing. The court also held that calls for an explanation requirement should replace the claim of manifest disadvantage. So Lord Nichols also brought this up in the test that 2A and 2B, which one party has trust and confidence in the other, especially financially, and something about that transaction that calls for an explanation. In Class 2A cases, however, the law irrebuttably has a presumption of influence, which is when a proof of special relationship exists. And finally, the issue of whether or not Fuad can claim under undue influence. Although the remedies for undue influence includes rescission, other than that, there is the burden of proof which still exists. As the scenario went on, we observed that even though they had a pre-existing special relationship where he also sought investment advice from Chandran and had a deal prior to this, it puts him in a very sticky situation because the bank's in-house lawyer carefully did explain the risks, which made Ford willingly sign the charges. And therefore, he is well versed in the risks and challenges he will face. Given that Chandran was absent during this time, it will be a bit challenging for Fuad to prove Chandran's dominance under English law.